Good afternoon. My name is Ryan Foltz. I'm an attorney at Beresford Booth. I've been practicing for 25 years, and for the bulk of that time, I've been working in construction disputes. My practice does include other areas of real estate litigation and real estate disputes. Today, I will be discussing the elements of a construction defect claim, how you go about preparing the claim, and kind of the process and elements of walking through the claim. Most construction defect claims follow a similar path. Usually, the beginning part of the dispute revolves around the scope of the work and what actually work was agreed upon. The performance of the work obviously is the issues in terms of whether the contractor performed appropriately. The deficiencies in the work, sometimes that's difficult to identify, as some of the work can be hidden or be covered up by other elements of the build, like by drywall, or if it's a roof and the underlying roofing materials are defective, sometimes it's difficult to identify those claims. I'll also talk about preparing a claim and the process and the elements and procedure of resolving a claim. The agreed scope of work is usually the beginning of any construction dispute. You'd think you know what you hired the contractor to do, but most disputes revolve around what was actually agreed upon in terms of the actual work the contractor was hired to do. So to avoid disputes at the front end, in terms of when you're contracting with the contractor, make sure that you have a written scope of work that is specific and includes contract specifications. The specifications identify the performance and the benchmarks to which the contractor needs to be performing his work. Any written contract should also make other references to elements that will be important in a claim, such as prevailing industry standards, installation requirements by manufacturers of the products being used, and then obviously the building code. So the next issue is, once you have a contract, how do you determine whether the work actually was compliant with the contract and what you agreed upon? Again, you're going to go back to the contract specifications, what was in writing, what was agreed upon, and what was the intent and the expectations of the owner at the time the contract was executed. Some easy ways to identify defective work would be if the wrong material is used, you specified a certain color tile and the contractor shows up with a different color tile. That's an obvious defect. Maybe the equipment is wrong or it was specified incorrectly. But frankly, the easiest way to find defective work is if the work is simply not performing. So if a contractor, for example, is hired to install a new roof or install new siding, windows, doors, those sorts of things. And after the first rainstorm, water is gushing through the roof or through the sliding glass door, the work isn't performing. And so that defective work is easy to identify. Another easy way to identify defects is with the building inspection process. Most significant remodels are going to require a permit and an inspection by the local building authority. And if any of the work is non-compliant with the code, the contractor will issue a notice of violation, identify the defects with the work, and identify the work that needs to be performed to bring the defective work back in compliance with the code. So what now? You've identified defects. There's definitely issues with the work. What are the options and how can you address those defects? The first place you should go to is the contract. Go back to the terms and conditions of the contract to identify whether there are any remedies in the contract for dispute resolution. Depending on the size and the scope and the amount of the contract at issue, there may be various particular procedures to address defective work or work that was not done in an appropriate manner. You should always demand repairs or demand that the contractor perform at his own cost and at no additional cost to you, work that is compliant with the contract, the specifications, and the code. That can be done informally, it can be done through email, it can be done via letter, but the demand for the work and the request that the contractor come back and complete the work in an appropriate manner is always an option that an owner has. There's also some financial options that you can employ. You can demand a credit in terms of money back to you for the work that was not done appropriately. Or if you have to hire somebody to complete repairs of the defective work, you can assess what's called a back charge against the contractor. for the value of the work or for the value of the repairs that you had to pay to complete the work in an appropriate manner. Finally, one thing that you should always do as an owner is withhold final payment until all issues with the work are resolved. A lot of times the final payment is tendered after what's called a punch list is performed. In other disputes, if you have large, significant disputes to the work, withholding of payment usually is a means and a methods to hold a reasonable sum that's going to cover the cost of repairs or remediation to complete the work if the contractor is not willing to come back and complete the work at his own cost. If you're not able to resolve a claim directly with the contractor, a claim may be necessary. And so how do we go about supporting and calculating the claim? The best place and the best method to do that is to make a written record of the defective work. So emails, letters, text, anything that documents and records in real time the work that was defective and any type of damages that were caused or any repairs that are necessary is really critical because in most suits, a year down the road, looking back in time, your memory can fade, details might not be available anymore. And so a good written record that's supported with photographs or any type of video evidence showing defective workmanship, improper materials, or damage is really critical to supporting it and prevailing on a claim down the road. You should also identify other costs that are incurred as a result of the defects, not only the repair work or new materials, but costs associated with delays in completing the work, which can include lodging if you're unable to live in the home or if it's a new home, or additional interest, for example, on a bank loan that you may have pulled to cover the costs of construction. One final thing to consider is engaging a construction expert to evaluate the work, identify necessary repairs, and calculate the repair costs. If it's a significant claim and a claim that you think may be on the path to future litigation, most of those claims, if not all of them, require some type of expert testimony to demonstrate the work was defective and to demonstrate what work was required to remediate the defective work. So bringing an expert on early is definitely to your benefit as an owner. Once the demand is made, there's a couple options to resolve the claim. Again, you can go back to direct negotiation with the contractor. If the contractor is a reputable firm or a stand-up guy and wants to stand behind the work, the contractor may be willing to simply come back and complete the work at his own cost to make sure that the work is compliant with the contract that you negotiated and executed prior to the work. There may also be a dispute resolution process in the contract, depending on the size and the scope and the level of complexity of the project. There may be a very specific dispute resolution process, or there may not be one at all. But some common methods would be requiring direct negotiation between the owner and the contractor, requiring notice to the contractor, and requiring mediation before filing suit or commencing formal action against the contractor. Washington State also provides a right to cure statute under RCW 6450. Under that process, a contractor is entitled to notice of the claim and specific notice as to what defects the owner is claiming. The contractor is also afforded the opportunity to inspect the work to determine what work is defective, and has the option to offer to repair or offer to settle the claim. The owners aren't required to accept those offers. The owner can simply reject any repair offer by the contractor, which frankly is usually the case once the relationship has soured to the point where an owner loses faith in the contractor. They frankly don't want that contractor to come back and attempt repairs. So if the owner rejects the offers, or if the contractor does not pursue his rights under RCW 6450, the owner, after a statutory period, can simply just file suit against the contractor. And that's the last option available to an owner, is to file suit. It's frankly pretty simple to do. It's effective. It definitely will get the contractor's attention. But just be forewarned that active litigation is definitely an expensive process. There are benchmarks and requirements once you file suit that require the parties to disclose documents, respond to requests for documents. There's a process called discovery where depositions may be held by both parties. And so it's a fairly involved process. It's time consuming. It can be stressful and it definitely can be costly. But depending on the dispute, sometimes it's frankly necessary to go that route. So when to engage legal counsel, I would say the sooner the better. We can help out folks, and we do it all the time, where we're presented contracts by an owner before they hire a contractor. We can review the contract, look at the terms and conditions, and confirm and let you know and that the contract is drafted in a way that protects your rights. We see a lot of one-sided contracts that are drafted only to protect the contractor and or exclude certain rights that an owner typically would have under a contract. So definitely a contract review for any type of sizable construction project is advisable. We can also help during the course of construction. If there is a dispute, we can help you navigate that dispute directly with the contractor. We don't have to show up directly to talk on your behalf. We can work from the background and help you and assist you in coming up with arguments and the claim with the contractor. But we also can put you in touch with the right experts to come out, look at the work, inspect the defective work, and help with the preparation of scopes of repair to remediate the work that's not appropriate. Finally, we can step in if necessary on your behalf. We do this all the time. At Beresford booth, we'll write demand letters to contractors hoping to get a response or an offer of settlement, or we can negotiate directly with the contractor on your behalf, hopefully with the goal of avoiding active litigation. So in a nutshell, that is the process. It was a very simplified summary of the elements and the process of a construction defect claim. But if you do have questions about either a construction contract before you sign it, or if you're having issues during the course of construction, feel free to reach out and I would be happy to answer your questions and meet with you and discuss your issues. Thank you. Have a good day.